Hi, my name is Kathleen Dartez, and I'm the Director of Legal Affairs for the Maryland Association of Realtors. Today, we're going to talk about a topic that comes up frequently on the legal hotline: service animals and emotional support animals. There's a lot of confusion about this topic, in part at least because there's a lot of conflicting information out there. Our mission today is to eliminate the confusion so you will be able to explain to your clients the difference between a pet, a service animal, and an emotional support animal, and to understand what you, your company, and your clients need to do to make sure you're compliant with the fair housing laws and with the Americans with Disabilities Act. Since we're realtors, let's start with the requirements of the Fair Housing Act, which covers almost all types of housing, including privately owned housing and federally assisted housing. The most important points to remember are, number one, service animals, therapy pets, emotional support animals, or animal aids, we're going to call all of these assistance animals, are all treated the same under fair housing laws. And number two, assistance animals are not pets. Therefore, any policies that the landlord has regarding pets are not enforceable with respect to an assistance animal. So, let's say your landlord client receives an application for tenancy from someone with an assistance animal. The landlord must treat this as a request for a reasonable accommodation and must consider the following two questions. Number one, does the person seeking to use and live with the animal have a disability, meaning a physical or mental impairment that substantially limits one or more major life activities? And number two, does the person making the request have a disability-related need for an assistance animal? If the answer to either question is no, the landlord is not required to modify his policy and may deny the request for a reasonable accommodation. If the answer to both questions is yes, federal law requires the landlord to provide a reasonable accommodation and allow the person with a disability to live with and use an assistance animal in all areas of the property where people are normally allowed to go. Let's talk a little bit more about the first question. Does the person have a disability? How does the landlord ask about that without getting into trouble? What kind of documentation can the landlord ask for to determine if the applicant has a disability and a disability-related need for an assistance animal? The answer, of course, is it depends. If the disability or disability-related need is readily apparent, the housing provider cannot ask the applicant to provide documentation. An example of this would be someone with a visual impairment who needs a seeing eye dog or a guide dog. Since the disability and the need are both readily apparent, the landlord cannot request supporting documentation. If the disability isn't readily apparent, the landlord can ask the applicant to provide documentation from a doctor or other medical professional to verify that the individual satisfies the Act's definition of disability. The landlord cannot ask for detailed documentation, and the applicant cannot be required to provide access to medical records or medical providers. So you got that? If the disability is readily apparent, you cannot ask for documentation. If the disability is not readily apparent, you can ask for a letter from a doctor or medical professional. So let's move on to the next question. Is there a disability-related need for an assistance animal, meaning an animal that works, provides assistance, performs tasks or services for the person with a disability, or provides emotional support that alleviates the symptoms or effects of the person's disability? What kind of documentation can the landlord ask for to figure this out? Well, the landlord can ask the applicant to provide documentation from a physician, psychiatrist, a psychologist, social worker, or mental health professional. The documentation is sufficient if it establishes that the individual has a disability and that the assistance animal will provide some type of disability-related assistance or emotional support. Let's go through some scenarios that you might face. What if you're representing a landlord who has a no pets policy and you receive a rental application from an individual with a disability who has a therapy cat? The landlord cannot reject the applicant under a no pets policy. What if the landlord requires a pet deposit? The landlord cannot charge a pet deposit for an assistance animal. What if the landlord has a size limitation, only allowing a pet up to 15 pounds, for example? No. What if the landlord allows dogs but won't allow cats? No. Also, the assistance animal is not required to be individually trained or certified or to wear any particular vest, collar, or tag. Okay, we've talked about what the landlord cannot do. Let's talk about what the landlord can do. The landlord can require that the tenant pay for any property damage caused by the assistance animal beyond normal wear and tear. The landlord may deny the request for reasonable accommodation if that specific assistance animal poses a direct threat to the health or safety of others or would cause substantial physical damage to the property of others, and these risks cannot be reduced or eliminated by another reasonable accommodation. Be careful here. The landlord cannot make any assumptions about a particular breed of dog or about a particular species or type of animal. So far, we've only talked about fair housing laws. Remember that the Americans with Disabilities Act, the ADA, also governs the rights of a person with a disability to use a service animal. The ADA applies to places of public accommodation, meaning places that are open to the public, like restaurants, shopping centers, movie theaters, real estate brokerage offices, title companies, etc. Under the ADA, a place of public accommodation cannot prohibit service animals or prevent someone with a disability from entering with their service animal. Within the scope of the ADA, the definition of a service animal is narrow. Service animal means a dog or miniature horse that has been individually trained to do work or perform tasks for the benefit of a person with a disability. Again, the most common example would be a guide dog or seeing eye dog for someone who's visually impaired or blind. Many of the questions coming into the legal hotline arise because most consumers are at least somewhat familiar with the ADA and with the narrow concept of a service animal under the ADA, but they're not as familiar with the Fair Housing Act and the broader concept of an assistance animal under that act. We've heard from realtors whose clients argue with them, "No, that's not right. The dog has to be certified, and this one isn't. I can reject these applicants. Doesn't the dog have to wear a vest?" and so on. NAR has prepared a chart comparing the differences between service animals or assistance animals under the Fair Housing Act and the ADA, and has graciously allowed me to share it with you. Please feel free to share this with your clients to help them understand the differences between the two acts. The key takeaway with respect to assistance animals is that they are not pets. Therefore, any policies that the landlord has regarding pets are not enforceable with respect to an assistance animal. I hope this video was helpful. If you have any questions, please feel free to reach out to me or Colette Massengale or Jason Brand on the legal hotline by calling 1-800-888-1272 on Mondays, Wednesdays, and Fridays between 10 and noon and 2 and 4. Or if you prefer, you can submit questions online by going to our website, mdrealtor.org, clicking on Legal, and clicking on Legal Hotline Web Question Form. Thank you for your time.